if everybody's okay, we checked everyone's mic, so thank you all for joining. We are starting now with exploring the legal framework for the outer space panel. We are having 90 minutes for discussion. At least 60 to 70 minutes will be reserved for our discussion, and then 20 minutes will be for selected questions from the audience, if there will be any, because I have plenty. We're trying to make this discussion as interactive as possible, so jump in whenever you want. We have additional facilitation, and as you can see, we have incredible technical support. Thank you, Rob, for being with us on the call. How we will begin this is basically, I would very much love to introduce every single panelist that we have and ask you a few questions, starting off with a question of what brought you to the space and what fascinates you after a couple of years working in this domain or starting to be attracted towards this domain now. This is our first space panel, so the objective really is to introduce the topic to our broader audience and through the lenses, of course, that you bring to this panel. So kicking it off, if everybody's ready, I'm really curious how we can actually describe this out-of-the-box panel. So I'll start with Alexander Souchek, who is the head of International Law Division at European Space Agency, the ESA, and you previously held the position of a legal officer for Public International Law and Space Law Program, and were a coordinator at ESA Directorate of Earth Observation Programs. Now, to my knowledge, you have also served as a legal advisor to ESA Directorate for Telecommunication and Integrated Application. What does that all mean?
What does that all mean is a good question. It means that I have maybe spent a few years in ESA in the past. So it's 15 years, in fact, that I had the privilege to go through various steps and stages at the European Space Agency. For those of you who are not familiar with ESA, it's an international intergovernmental organization. So not only is it fascinating what ESA does, but also how ESA does things, because it's not a national space agency like NASA, although we do similar things in terms of output. We fly into space, we explore, we use outer space, but the mechanism is a different one. We have 22 member states, and so a lot of what we do as lawyers in ESA is to coordinate and to make decisions possible and to implement what our member states want us to do in a legally sound way. So that's a bit what I'm doing. But your first question was actually how we all ended up in this field in space. And for me, it's actually very simple, and I'm very happy about it. I'm one of the few space people who discovered law later on, rather than many lawyers who discover space once they have studied law and look for a career somewhere. Since my very early childhood days, well, say like 5-6 years, that was the time when I got my first telescope, I was fascinated by space and by space flight. I'm a hobby astronomer. For more than 20 years, I was guided our local observatory. So really, I have my telescope out on the balcony there. And that is the very simple answer also to the question, what motivates me every day to go to work? It's this profound passion. And when I was 18 years old and left school, we had this little interview session. What do you want? Where do you see yourself as a grown up later on? And I remember I said into the microphone, I think I will work in space. I wanted to study astronomy. Then it became law, quite different, but still through the back door, I am, I think, exactly where I dreamed to be as a child.
Incredible. You don't very often actually hear people switching from a domain into law. That's quite exceptional. Very huge respect towards those people, absolutely. And then we have Jennie Tapio, who's a chief specialist at the Ministry of Economic Affairs and Employment at Finland. Now, you focus on space activities and also represent the Finland at the United Nations Committee of the Peaceful Uses of Outer Space, which is part of the UN. You are also head of delegation for legal subcommittee, and as the alternate head of delegation for the main committee. You're also a vice chair of the European Space Agency International Relations Committee and a delegate at the Industrial Policy Committee. And as far as I know, previously you used to work in a private sector specializing in technology, telecommunication, satellites, and space law. And you worked with Bird and Bird attorneys as well as the Airbus Defence and Space and Nokia Corporation. So I'm really curious what brought you from the private sector towards ministry.
Hi, Anya. Nice to see you. I guess my answer would be that it's partly just things happened, but it's also a bit of a passion. And I think my passion initially was to technology. So that's how I ended up working with Nokia and Airbus afterwards. But at all times, I've also had a passion to law, and especially to public international law, and sort of like had a dream of becoming a diplomat, say, at some point. And let's say that space sort of like brought these things together so that it was meaningful, that I had this experience from other fields of technology. So I had the private experience coming to the public sector, but still it sort of like in a meaningful way brought then this, let's say, childhood dream of being involved in international diplomatic relations and being able to talk about public international law for your work. So I think that's in a way a nice result of things coming together.
All right, that actually brings me directly to Primavera. Maybe not so much on diplomacy. However, there is a lot of governance talks that we have been engaging into. Primavera is a permanent researcher at the National Center of Scientific Research in Paris and a faculty associate at the Berkman Klein Center for Internet and Society at Harvard University, and a visiting fellow at the Robert Schuman Center for Advanced Studies at the European University Institute. So Primavera, your research focuses on the legal challenges and the opportunities of basically blockchain technology and artificial intelligence, with the specific focus on governance and trust. And you yourself are a lawyer as well and a founding member of the Global Future Council on Blockchain Technology at the World Economic Forum. So my big question is, how do you find yourself in the space, or what interests lie there? Do you feel like, global governance is just one step towards an improved or the beginnings of the space governance, or how did you get into this domain?
So actually, I think it's quite funny, but I think you were perhaps the first one that I remember having a discussion about space and law and being like a little bit in awe about like how it actually had a lot of similarity with blockchain. But then I kind of like let it pass, and I focus mostly on blockchain and like essentially I think I'm one of those lawyers that is desperately looking for specific use cases to show the limits of law and the importance of governance. And blockchain technology is a very interesting use case for that. And my goal as a legal scholar is really to research the question of governance, but at the community level, at the institutional level, and at the global level. And so blockchain has been for a long time a fantastic little field of exploration as a microcosm that somehow can, if we can figure out governance at the blockchain level, perhaps we can figure it out at the larger social level. And then, so I brought a little surprise to this panel. We have an extra panelist, which is actually perhaps like the strongest gravitational force that has brought me towards like the thinking about space and governance. Which I will let Jessica introduce herself. But basically, what really happened, like basically at the end of last year, was like I found myself into this community of like space geeks, and very interested in talking about governance. And we started talking about governance, and I actually was only talking about blockchain governance, and they were mostly talking about space governance. And we realized actually that we are talking about global governance, and that there is so much amazing insights that I was taking from the space governance questions. And I felt that there were quite a few things I could also contribute from my thinking in blockchain governance, because in the end, there is this commonality into both of those spaces, which is how do we operate into a space where there is no coercive power, in which there is a multiplicity of actors with different degrees of influence that needs to find some kind of coordination around each other, because there is a benefit and on all this thing. And so all the thing about mechanism design that we're thinking into the blockchain space actually could also apply potentially for the space governance question. And in the end, all of these can also and hopefully serve the interest of thinking about global governance or global governance issue at the planetary scale.
That is incredible. I mean, I'm taken by surprise, and I do love surprises. So I'm going to, before we go to Christopher Newman, I would love to give you the floor to introduce yourself as well. Absolutely.
Sure, yeah, I'll just briefly say, for some context, that Primavera and I have been collaborating for a while. And so I lead the governance and policy research at something called the Open Lunar Foundation. And that's a really fun project. But I think often in the space community, we don't look enough to existing analogs of kind of law and policy and regulation in the terrestrial domain and build off of what we have learned in the past in order to create models for the future. So Primavera and I have really connected over the idea of kind of zooming out from our respective kind of specialties and finding the patterns between these different domains that we can use to kind of to inform designs for the future. So I'm excited to be here. Thanks for letting me unconsensually crash your panel. Looking forward to contributing.
Thank you so much. Yeah, absolutely welcome to the panel as well. There's going to be possibly plenty of questions that are going to be referred to both of you. I can already see how this is an incredible contribution as well. So next we have Professor Christopher Newman. You are a professor of space law and policy at Northumbria University at Newcastle here in United Kingdom. A PhD. You know, you're active in teaching and researching space law and have published extensively. There's been plenty of TV shows, and the BBC has been constantly inviting you to talk about the space laws. You've also graduated at University of Sussex and have been teaching this for years. I do have a question for you, and that is there any question that you get bored of? Is there like a specific question, like everybody asking you, really space laws exist? Or do you ever get bored of that?
That's exactly it. And yeah, it's the first. I didn't know there was laws in space, and it's, you know, it always sort of forces me to smile and, you know, concentrate and think, yeah, of course there's laws in space. But of course, it's a natural question, because I suppose people, one of the problems I think that we're going to see and we're going to explore is that, you know, we see it with environmental law, we see it with a whole range of other laws. If people can't see it, they can't conceptualize it legally. So it's space. I think it's all part of space's identity crisis, that space is seen as belonging to other people. It's belonging to them. It's belonging to, you know, people with the right stuff, people with rockets, people with, it's not seen as belonging to us all. And I think that's kind of part of the problem. And that's why you get the question of, yeah, so is there really space law? So you're absolutely right. That's exactly the question that I get asked all the time.
And since we started here or ended here, before we go back to the technical questions, would you be kind and provide us with a bit of an overview of what are the space laws? What does that even mean? How broad is that? Since when does that even exist?
Well, I was going to say, we're fortunate on the panel. We've got some of the most amazing space lawyers. I mean, Alexander Souchek is you know, one of the greatest in the world. Jennie is making the space law. We've got a whole range of people on here. So I feel very humbled. But what I'll do is I'll just start off by saying that actually space law almost predates human space activity. There was discussion of it in the 1920s and the 1930s. And as soon as humans went into space, as soon as we had Sputnik go into space, the United Nations kind of kicked into action. The time that space activity started, we were fortunate in the sense that there was this sort of gravitational pull around these big international organizations, a pull that I'm not so sure exists anymore, or certainly not to the extent we saw in the 50s and 60s. But the Committee on Peaceful Uses of Outer Space was formed as a committee of the United Nations to report to the General Assembly to provide advice on how to deal with this new sort of domain of activity. And We saw in the early 1960s some General Assembly resolutions establishing the building blocks of what we come to recognize as the central trunk of space law, and certainly the central trunk of international space law, the Outer Space Treaty. You'll hear it mentioned a million times as we talk throughout this panel. The Outer Space Treaty, the central trunk of international space law. It has little children treaties as well, treaties that sort of were spawned by it because of the contents of the principles that were there. But we have this fundamental treaty of principles of how humans are going to behave in outer space. And it contains, behavioral principles and things that we can do and things that we can't do. It has, responsibilities. It's a treaty. So it's a relationship. It's relationship between states. So the law is addressed, the international space law is addressed to states. It's states must not do this, or states have freedoms to do that. And states then trickle down that and regulate their own space activity. So that's kind of a brief overview of the international picture. And underneath that sort of top of the pyramid, we have a whole range of national space laws which give effect to the state's obligations under the international treaties.
And this brings me to the question that we addressed previously with Alex. Since this has been existing for a few years, how much has changed? Are those principles written in the Outer Space Treaty still valid, or are countries looking into replacing these with new international treaties? Is that going to change, or is it like permanently written in stone? And do we really want to abide by those principles? Are those even or are they perhaps even the customary principles today? What's your
I think the customary element is an interesting discussion, and it's probably a discussion that if you get 10 international lawyers in the room, you'll probably get 10 different sort of variations as to whether the Outer Space Treaty is customary or not. I think there are certainly elements of it that are customary, but what we have is, as I say, because the principles were put down in the 1960s and they've sort of followed through, they've followed the trail of human space activity right the way through. I think we now have a treaty that is sort of fairly well embedded in the international community. We look at the Artemis Accords that have just been signed. They put the Outer Space Treaty front and center. Compliance with the Outer Space Treaty is a central sort of principle of that. And look at national space legislation. All of the national space legislation states that we're complying with our obligations under the Outer Space Treaty. So there might be academic discussion as to whether it's still as robust as ever it was, or whether we need to move on. But actually, you look at the real key elements, the key actors, the states, they're still nodding towards it.
Alex, Jennie, what is your perspective? You are kind of working with the states very closely.
Yes, who do you want to hear first?
Let's go with you.
Okay, sorry, Jennie, I didn't mean to jump the line in any way. First of all, thanks to Christopher, who just did an amazing job in summarizing in very few minutes what the essence of space law is. That in itself is an art. And now I understand fully that you on BBC or on other channels really had this difficult task already in the past. So thank you for that. And I just wanted to repeat essentially what Christopher just said. I always say the Outer Space Treaty is old, but it's not outdated. Right? There is a difference. Yes, of course, it's old because it has been written in the 1960s. It entered into force in October 1967. And when we think what 1967 meant at that time, the early days of space flight and also in society, in geopolitics, in history, then we realize that's a while ago. However, when you look at what is actually written in the Outer Space Treaty, then you see that many of those elements, I'm not saying every single word, but I say that the most profound, important central elements are actually timeless. The fact that states are free to explore and use outer space in principle, that you shouldn't cause harmful interference, that you should take liability on for damages you cause by exploring that freedom that society granted to you. That you're responsible for what your non-governmental actors in your country under your jurisdiction are doing. These are principles that don't just grow old and you can drop them in a bin because expiry date has been reached. So this is for me really, really important. I'm not saying that the Outer Space Treaty or any other law is carved in stone for eternity. Law has to develop, but you always have to look, what are the principles enshrined in a certain piece of law like the Outer Space Treaty? So for me, the Outer Space Treaty is not at all outdated. It might be complemented by other legal instruments. It might be further interpreted as we go along to explore outer space. But as I said, the principles themselves, for me at least, as a space lawyer, many of those principles are as valid in 2020 than they were in 1967.
Perfect. And Jennie, do these principles, even though they are very flexible, give us enough ambiguity or enough space to maneuver on a national level as well? And how do actually national states then maneuver around those principles, or maybe not around, but within those principles?
Well, yeah, and just to really echo what Chris and Alex already said about those principles, I think, clearly those principles, especially the principle of responsibility and liability, are the main motivations, if you wish, for enacting national space laws, and especially Article 6 mandating or some sort of authorization and supervision are in many cases the reason to have a national space law. And just to refer to our case, for example, where it was really that it was specifically said that within our constitution. So this is really a mixture of international law and domestic law that you have to consider when making national space laws, that you actually have to prescribe such obligations which are restricting the business possibilities at national level, at the level of law, to prescribe at clearly and in a predictable way what the operators can and cannot do. But of course, then there is that other development that we no longer have those binding treaties, but rather have more or less guidelines and standards, and how to implement those at national level is then also yet again another question, and to what extent and which one of those instruments are to be taken to interpret the existing treaty framework.
Mm-hmm. Primavera, that actually brings me to you, because there's been a lot of talks in the blockchain domain when we just discussed, there's no regulation just yet because this domain is so fresh and new. Nobody really knows how to regulate it because it's so decentralized. Is that a parallel that we could draw between the blockchain ecosystem and the space, and also maybe with regard to liability and responsibility, because it's just so hard to identify who the right actors are?
Yeah, so to me there are two very interesting dynamics that I've been observing in the few months in which I'm really looking at this intersection. And so the first one is that so in the same way, like if we take we have the traditional sovereignty of nation state on their territory, and then we have the blockchain that all of a sudden is this thing that is not just transnational, but is operating with specific principle that makes it hard for a government to apply the traditional mechanism of regulation that they have been employing in order to regulate the internet. And so all of a sudden there is, on the one hand, this form of extraterritoriality that emerged out of the blockchain, which raise new questions. And a lot of thinking today in the blockchain space is actually to which extent is a blockchain some kind of a legal entity? To which extent does it actually has some level of interaction with the existing legal world? And most importantly, as more and more people want to start interacting via the blockchain with existing institutions, then it actually becomes, the question is no longer about how do we regulate this creature, but it's more about how do we connect and how do we actually enable to create gateways or communication channels between existing institutions that are regulated in the traditional sense and those new types of of institution or like blockchain mediated organizations. So on the one hand, I feel there is a commonality in the sense that both of them exist in this, one is virtual, the other is actual physical extraterritorial space. And therefore we need to think about how we can create bridges between those different spaces. And the other place where I'm also increasingly curious to look at is to the extent in which we do have, we have to fully comprehend and understand how do we actually achieve this form of like global intervention and coordination on something that is outside of a single jurisdiction, perhaps using the tools. So on the one hand is looking at the blockchain as a particular microcosm, which illustrate the challenges and the needs that we need to focus on in order to create links between existing institutional frameworks and those new extraterritorial spaces. But on the other hand, it's like because we don't actually yet have proper tools to deal with those form of those links are not existing yet. And so within the blockchain space, there is a lot of innovation that is emerging about trying to create mechanisms, for instance, for like, because we cannot rely on the traditional law enforcement, then there is mechanism of private arbitration, of alternative dispute resolution system. So there are ways that are being developed which are trying to solve the problems internally within that own framework. And so what I'm very curious as well is to see the extent to which these solutions that are being experimented locally or virtually within the blockchain space could be leveraged and perhaps could serve to also serve the interest of global governance or space governance, because those infrastructures by definition are infrastructure that are not under the control of any single nation state, and therefore there needs to be this form of coordination and governance at the infrastructural level. But if we figure this out, then we could use this infrastructure, whether it's because of registries, whether it's because of just like creating rules of accountability and traceability, then it becomes possible to somehow accommodate the need of monitoring and coercion or sanctioning, and instead replace it with a mechanism of actual just verifying everything that is being done, so ex post verifiability, and instead of needing ex post sanctioning or enforcement, we could have a system of ex ante automation. And so codifying specific rules into this shared infrastructural platform so that we know we don't actually need to have this higher level of coercion, because the infrastructure by its own design will actually automate those rules. And if anyone is not respecting the rule, it will be immediately verifiable.
So this has become very, very complicated. And to some extent, I would like to bring us a bit back, just a few steps back to the responsibility and not really just the responsibility, but maybe even the control and the monitoring that all the states need to still do whenever it comes to their activities in space. And that is something that you mentioned previously, Jennie. What are the obligations that states are having? And is there really maybe a case within the space industry as well, where states do not have the possibility to control? Like I heard of the autonomous launching stations or autonomous technology being used in space sector as well. But does that mean that countries or states no longer have control over that infrastructure, or is that still being covered by the space laws?
Right. Well, that's an interesting and very multifaceted question. But if just to sort of like start from the notion of control, which is in national space laws usually taken from the perspective of international law, so the state having territorial or personal jurisdiction over entities or activities taking place in their territory or their nationals. And the notion of control is therefore that the state has some sort of ability to know and to control those activities taking place in their territorial boundaries, let's say. So the notion of control whether or not that means that you actually control activities taking place, because those are, especially if those are, by your non-governmental entities, for the reason mainly why you have to have a national space law. So within then that sphere in your national space law, you then devise certain mechanisms. How do you imply that control over the activities, even if those activities will then eventually take place in outer space beyond your national jurisdiction and your national territories? And most importantly, of course, then you have the idea of registration and applying your, say, extending your own system through such a legal mechanism. But of course, there is currently a lot of discussion whether the legal ways of controlling are simply enough, or whether more, let's say, advanced technical means of actual controlling should be, and knowing about what is happening with the activities in outer space that have been, let's say, initiated in one particular country and within the jurisdiction of that country, but are actually taking place and in a territory that is beyond that sphere.
Wow, that's incredible. Thank you for that. I mean, that actually, yeah, sure, go ahead. I was just about to make a reference because I do believe that this is exactly what Primavera was previously talking about. We might be using the technicalities for allowing us for better governance and implement these solutions. Go ahead.
Yeah, I was just gonna maybe bridge them a little bit and reflect that all the way back to what Chris was saying earlier, the Outer Space Treaty and the other laws that we have in the outer space domain address states specifically in a way that is sort of stronger than the majority of international law, I think. I mean, I'm not a lawyer, so I'm probably speaking imprecisely, but what's really interesting about the blockchain work and the blockchain space is that there's this opportunity for looking at how can we coordinate amongst, say, private actors who are not sort of seen in the same way in the realm of outer space law. They don't have the same kind of agency or primacy in that domain, and blockchain kind of creates this opportunity for them to organize amongst themselves in a slightly different way. And so I think it just sort of like enriches the ecosystem of possibilities, and bringing those two together as we start to see. I mean, right now we're seeing a lot more private activity in outer space. And also diversity of actors in outer space. And so, again, all these tools coming together in a way that creates this kind of dynamic ecosystem is quite interesting.
Mm-hmm. If I can add to that, I think that there's also it's also a risk in the sense that because it's difficult for governments to come to consensus, for governments to impose their own consensus onto others and so forth, like what kind of sanction can you put in place if someone is not respecting the rules of the treaty? There's also this risk that there is actually increasingly private companies that are actually jumping into, and take those private companies, unless they can be regulated by their corresponding jurisdiction, they can create among themselves their own rules, privately orchestrated, which could potentially go against the original intention of what the public treaty was. And so to me, there is really a need.
Oh, I think we lost Primavera for a bit.
And it's like a strong invitation to really think about this. It's like we cannot keep thinking about asking governments to coordinate themselves. We need to engage civil society. We need to engage private companies, and even though they exist on a different layer, to some extent, for all practical matter. I mean, and we see it with the internet, with like companies like Facebook, that we don't really know anymore how we can regulate them, and so they kind of impose their own jurisdiction onto this virtual space of the internet. And so I think, to me, there is like, on the one hand, there is like, what are those different nation states agreeing to, and that's kind of like the formal protocol. But then, as blockchain communities have taught us, there is the formal protocol, and then there is everything in between, and there is the tacit governance, and there is like all the informality where so many actors come into play. And actually it's extremely important to recognize who's actually playing those influence and bring them all around to the table.
So just before we dive into that, I do want Jennie to respond to, or at least if you have the response, because I heard that the governments can no longer do that alone. Does that mean that what the governments are probably not obsolete, but do you really need help from the private sector and from somebody that is dealing with technology, or how does that actually happen? What dynamics do you observe?
Well, I think it's certainly, it's a cooperation. I mean, it cannot be something that states do alone. I mean, it necessarily needs to be a discussion amongst all the actors. So, I mean, definitely, and that has to be at national level, but also very importantly at international level and between public and private. So yes, I mean, definitely it's a thing to cooperate with and not to go about alone, but to what extent, I mean, it's also about who are the actors and who have the ability to act, but also who are in the position to actually to formulate the norms of behavior, let's say, for those activities. And very traditionally, it has been the states who have been in that position at international level or at national level. But increasingly, of course, then we have various types of initiatives by non-governmental entities and private industry of self-regulation and so forth that are also looking into that domain.
And Alexander, how is the ESA placed here? ESA is just one of the international agencies that deals with the space laws, right? We also have NASA, we have JAXA. So in every continent almost, we have these international agencies. And is it that there's a hierarchy in place so that ESA is, for example, the highest body for all the national states, or is there also very much transversal effects? And I mean, what is it? Is it the vertical domain, or do you still cooperate with all the nations in a very horizontal manner?
Thank you, Anja. That's an interesting question because it allows me to go a little bit back to what ESA actually is, and that's very important. To make it simple, ESA is not a regulator at all. So when we speak about writing space law, when we speak about monitoring, when we speak about controlling entities, forget ESA. ESA is not writing space laws, and ESA is not monitoring the implementation of space law in its member states. So ESA is something very different. ESA is a very classical, though fascinating, but a very classical mechanism of cooperation and coordination between its member states. So it's an international organization in the best and most fundamental sense and meaning. 22 European countries going together, pool forces, money, experience, knowledge in order to fly space missions together. That's what we do. And because we do that, of course, for us, space law is very relevant. International space law, most of all, because we have to comply with it. We are, as an intergovernmental organization, a subject of international law, a derived subject, dependent on the will of our member states in our existence. If the member states want to dissolve us, so may it be. We hope not. But you see, we are really a derived subject. Space law talks to us. We have declared acceptance of some of the UN space treaties, those which we legally can, because the Outer Space Treaty, for example, does not foresee the mechanism for an intergovernmental organization to unilaterally declare acceptance. But the Liability Convention or the Registration Convention or the Rescue and Return Agreement, what Christopher referred to as the little children of the Outer Space Treaties, very nicely, they foresee that mechanism. And so we've done it. And we have to ask ourselves, are we compliant? Do we do the things we do in line with international law? And I think we do so because we really put a lot of care and attention into it. Now, just to add, what we, however, do in terms of helping regulators is that we are in close contact with our member states. And if they need our help and advice in order to write a national space law, or in order to implement a national space law, then we are ready to help, because we have a lot of experience from a technical, practical side. So when a new country writes a new space law, they have no experience whatsoever, or not much, in regulating space activities. What we can do is we bring them together with other regulators of the big ESA family, other governments who have done so already. We tell them what options there are to define in a national law a technical term like a rocket or an orbit. We help them also when it's about questions of implementation of space law. Like they can come to us and say, look, we got this application for a satellite mission. We don't know if we should say yes or no to it. And under certain conditions, of course, very controlled conditions, we can give an advice, but we will never say you have to say yes or you have to say no. We only can tell from our technical point of view what our opinion is. Well, looking at their papers of it seems they adhere to the technical standards we also adhere to. It's all complete. So that's from our side not a showstopper. And then it's up to the government to take this opinion into account. So this is what ESA does. It applies space law for its own missions, and it helps regulators in its member states to do their job if they want so.
Mm-hmm. And previously, you made a reference to the children of the Outer Space Treaty, and I do want to know and learn more about what are all the rest of the treaties. Now, we heard about the Liability Convention, we heard about Registration Convention, the Convention for Astronauts. What are all those? Christopher, can you help us out? How is that, like, how do you weave all them together?
So, Anya, you are right on the money there when you say weave all together, because I think, although I call them children, they are very much a family, and they are interrelated, and they speak to each other and with each other, much like the articles of the Outer Space Treaty do. So what I'll do is I'll take us back to the Outer Space Treaty, the OST, and some of the principles in there. For example, the notion of liability. It's a small paragraph in the Outer Space Treaty. It essentially says that states are liable for damage done by their space objects. Doesn't define space objects, doesn't define damage. So there's issues that need clearing up, and that the principles need expanding. So at the time the Outer Space Treaty came into being, Copius was very active in realizing, because as Alex said, we were right at the heat of the space race. We had humans going to the moon. We had a race to the moon. I mean, 1967, there was no sort of guarantee who was going to get there first. You know, the Apollo craft had just had Apollo 1 fire. The N1 rocket was looking like it could beat the Americans to the moon. So there was no certainty. So what we have in the Outer Space Treaty is a statement of principles that are essentially looking to the peaceful coordination of space activities. So we have what I call the accountability triangle in the Outer Space Treaty of Article 6, which makes states internationally responsible for their private actors that we've talked about. We then have this concept that's almost separate but very closely linked under Article 7 of the launching states being liable for damage. 4 ways in which you can become a launching state. And then we have the incentive to register. Article 8 endows jurisdiction and control to space objects with a registry attached to them. So we have that little sort of triangle of accountability, but each one of those concepts needs unpicking. So we have the Liability Convention, which pulls details about what type of liability. Are we talking about liability in the air? Are we talking about liability on the ground? Or are we talking about liability elsewhere other than the surface of the earth, which is the language the treaty uses? Okay, do we, should there be different levels of liability? That, if a rocket launch goes wrong, that could have impact on human lives. But if 2 robots bash into each other in outer space, is that as serious? So there might be 2nd, 3rd, 4th order effects, but it's not as serious as especially if you're a non-space actor and you just happen to be unlucky underneath a space object that returns to Earth. So that all needed balancing out. Similarly with registration, how do we register? What needs to be on the register? What are the terms of register? All of that needs to be covered. Let's not do it in the Outer Space Treaty. Let's negotiate it separately. So we have these as I say, the little children treaties, which expand upon the central principles we find in the Outer Space Treaty. There is one that we haven't talked about, the Moon Agreement, one that didn't gain the international acceptance, sometimes referred to as a dead treaty. I don't think that's particularly fair, because it is still a treaty. States have still ratified it, still observe it, but it hasn't gained the international acceptance, and some states have actually repudiated it. So that's the broad span of, if you like, space treaties and what they do and why they're related to each other. So registration it's a significant element when we're thinking about liability, because part of the liability convention actually apportions the sort of the burden depending on who has the registry. It all kind of links together, and that's how I would think about it as a family that relates to each other.
You said that the Moon Agreement is not gaining so much traction. What is the main stumbling obstacle on the road? I mean, it sounds incredible having a Moon Agreement, and since we are having some robots on the moon, I mean, it would make sense to have that type of an agreement in place, but why not?
Now, I'm going to go against what international law says here. The Vienna Convention on the Law of Treaties says that historical interpretations, they only play a small part. But I think in space law, actually looking at the year really helps us understand what the treaty is meant to do, what it's looking to sort of protect, or what principles it's looking to advance. So we have the Outer Space Treaty 1967, we have the Rescue Agreement 68, Liability Convention 72, Registration Convention 75, and then we have a gap of 4 years to 1979. Now let's think about the world in 1979 to the world in 1967, dramatically different. Apollo had come and gone. The activity was coalescing around low Earth orbit. And on top of that, what we have within the Moon Agreement is quite a controversial principle, the common heritage of mankind principle. And Article 11 of the Moon Agreement suggests that the moon of the celestial, outer space, the moon of the celestial bodies are common heritage of mankind. Now, this is a controversial principle, largely because a lot of academic scholars certainly can't agree what this actually means. Okay, you might say that's not necessarily a problem, but it is for the states who are looking to use the resources of the moon, because the common heritage principle dictates the equitable sharing of those resources. That became a big stumbling block for a lot of nations. So that's why we see, for example, although the Committee on the Peaceful Uses of Outer Space, America and the Soviet Union negotiated the Moon Agreement, they were very quick to sort of push themselves away from it and actively say, no, not only is this not a treaty that we're not going to sign, this is a treaty that we are repudiating. We don't want to be bound by this. So essentially, Article 11 is the problem in the Moon Agreement. I mean, I think there's possibly other issues, but that's the area where we had problems with this issue of resource allocation.
So it sounds as if we would, again, need to approach or address the governance issues. And Primavera, I know that you have been researching a lot the polycentric governance. And since you've been talking to us about the consensus protocols, and you're also the co-author of the book, Code is the Law, or Code as the Law, tell us something, tell us more, tell us what we are missing. Like, how can the code here contribute to an improved governance or polycentric governance?
Yeah, so that was Laurence Lassig that wrote Code is Law. I built upon it in order to discuss in the context of blockchain how we have the rule of code, meaning that we are ruled by the code as opposed to by the law, but in a slightly different context, in the sense that it's more about saying that we are now using and trying to embed those technology within the existing legal framework, right? So Code is Law was more about saying on the internet we use code, and code has the effect of law, whereas increasingly now it's actually existing regulatory authority, national institutions that are adopting code as a tool of enforcing their regulations. So to me, like, what is really interesting, especially when we move into like a polycentric system, is that once you don't have this kind of sovereign, and either you, like, basically when you enter into a system of necessary interdependencies, either you need to coordinate multiple actors, and so either you go through the creation of a higher level entity that will become the centralized coordinator, and that's probably the most efficient. But of course, that means that every actor needs to actually subjugate themselves to the decision of this new entity, which is very unlikely to happen, especially in this field. And otherwise, it's actually about disconnecting. And of course, in that case, it's not a possibility, because there is like people will go on this space, and like the interdependency is inherent into that new territory. And so then the third way is like, how do we actually accept the fact that we live in a space of polycentricity, and how can we, what are the tools that we can leverage? And so according to Ostrom, for the management of common resources, when you are like, it is extremely difficult to achieve some form of decentralized coordination unless you have two specific items, and one is a mechanism of constantly being able to monitor the actions of other people, and the second one is the capacity of actually imposing some form of sanctions whenever someone is not respecting the norms, right? And so this is like, you can look at it at the level of like a common pool resources, you can look at it at the level of international law, and you can look at it at the level of like space. And so the question is like, can we use technologies that can help us solve this dilemma? Because monitoring equals surveillance, and sanctioning means that there is an enforcement authority and that there is a coercive power that currently we don't have. And so the research that I'm actually trying to pursue in the coming years is trying to look at this question, like, if we want decentralized coordination because we want to remain in a polycentric system, but we cannot have constant monitoring because we don't want to live in a system of constant surveillance. And we also don't have the tools to have some mechanism of centralized enforcement or sanctioning. Can technology help us? And that's where blockchain technology comes back as a potential, at least as a hypothesis for this, which is you don't really need monitoring if you have a way of recording information and no one needs to know anything about that information, as long as the infrastructure is such that there is ex post, when needed, the possibility of proving and verifying something, right? So instead of having an entity that is constantly looking at you, there is just an agreement that we all gonna commit proofs of actions onto this shared database. And by the mere act of committing those proofs, we're to some extent holding each other accountable, because we know that we can verify ex post whether or not we have been acting correctly, but without having to monitor everything. It's only when something goes wrong, you can go back and ask everyone to disclose their proof that they actually are in the right. So that's one solution in which blockchain technology could actually replace the need for constant monitoring through a mechanism of verifiability only when needed. And in terms of something in terms of sanctioning, basically it's about, so we all anyhow need to agree on specific set of norms, but the problem is that we don't have, and we don't want to create this new coercive power around it. And so we can either rely on like specific sanctioning, the bilateral mechanism of like sanctioning each other, or we can actually tie our hands to begin with and actually codify some of the rules, the one that can be codified on an infrastructure that no one has influence over, that no one can actually impose their have a coercive power. They cannot stop it, they cannot influence the execution of it, and so forth. And so in that way, sanctioning becomes obsolete, because violating the rule to begin with is not possible, and only if there is an action, because of course we cannot predefine ex ante all the possible norms and rules that will evolve, but only when there is a consensus at the level of the governance of this shared infrastructure, so whoever are the members of this consortium, then we can change the rules, right? And so instead of having a mechanism oriented towards sanctioning, we actually have a mechanism oriented towards when is it, we automate everything so there can be no violation of the rule. And then we need a governance structure to decide together when do we want to allow an exception or when do we actually want to modify the rules of the protocol.
I do want to bring some more, thank you for that explanation. It was really good to hear all about the consensus and the specificities. All right, so just to circle it back into the controlling and sanctioning, what happens right now? Because these sounded as if, you know, we might be having systems in place for the future that might help us here. But what happens today if, for example, a country or if a company breaks the rules in terms of, let's say, some satellites does some damages? What happens? That company loses a license, or is there a process in place? Maybe, Jennie, you can provide us a bit more insights into that topic.
Maybe if I just answer from the national perspective, but I think it would be nice to hear from Alex or Chris to sort of like address the international one. But so at the national level, so if an operator breaks the rule, the rule set to it by the license or by the law, then you have the national mechanisms that will start to get on. So let's say that there was a fictional case where a national operator caused a damage in orbit, where and then for a reason or another the national state had to pay, so money had to leave the state's treasury. It would then usually have in its national law a mechanism to go back to that operator and through a right of recourse and to retrieve, let's say, if certain conditions that you have within your national law were fulfilled. And usually this is also a bit tricky. And since we don't have a lot of examples as to how to do that, so the national application of, for example, fault liability might be very tricky in practice, but I think it's also deriving from the fact that it's very complicated at the international level, and there is that other dimension that's very interesting too.
Oh, somebody please explain the liability in space law from the international level. I know that there's two types of liability, or one is fault liability and one is not fault liability, and it depends on where the damage was caused, whether it was on Earth or whether it was in space. Please explain. Maybe Alexander, you want to take on that?
All right. Although you just did it yourself. You just explained the essence of it, the very essence, space law liability in 30 seconds. Yes, in principle. And now we talk about international law. Yeah, we talk about the, let's say, the system that the Outer Space Treaty, but more than so, the so-called Liability Convention that Chris mentioned before, established. And that is indeed simple. Well, it's not that simple, but we can break it down to some so-called simple elements. That is indeed, it depends where a damage is caused. First of all, a space object needs to cause that damage. That's the first thing. But then it depends where it has been caused. If the damage is caused in outer space, then indeed, before liability can be triggered, before a state becomes liable for that damage, there needs to be one element, and that is fault. So be it gross negligence or be it something even stronger than that, there needs to be this personal subjective element. You have handled things in a way that were not correct according to standards. But here we come already into the problem that it's very difficult to establish fault in outer space. When it's about a damage on the surface of Earth or to aircraft in flight, then there is something what we call absolute liability. That means, first of all, a fault is not required. You become liable simply by the fact that you caused, or your space object caused, a damage. And it's financially unlimited in principle, and unlimited in time also. And when people hear that, they are often astonished why there is this this difference. But it's not so difficult if you look from a conceptual point of view why that was introduced. The simple answer is that states profit from the freedom to explore and use outer space granted in Article 1 Outer Space Treaty, right? So you can say society, the other states, all states together in this big game called public international law, granted that freedom to everyone. So if you profit from that freedom by going into outer space, and then you cause there a damage to someone else who profited from that freedom and also went into outer space, you can apply the rules that you would usually apply also on the ground. However, if you cause damage to somebody that has not profited from your freedom, that is basically suffering the fact that you can go up there, and then you drop your spacecraft onto the roof of that somebody, then that somebody should be specially protected. Hence, not have to argue whether it was your fault or not. Get the money right away from you. I'm simplifying very much, but that's the basis for having this distinction between fault-based liability in space and absolute liability on the surface of Earth. Both of them were hardly ever triggered in the history of space law. That we have to add that. There have been luckily not many accidents. Of course, there have been, and some very tragic ones, by the way, in the history of space flight. Also, people lost their life, but that was usually not a problem of public international law where a third party suffered that damage, like when Space Shuttle Challenger, for example, exploded in January 1986, or Columbia crashed upon return in February 2003, or a rocket explodes on the launch pad. Those are very dramatic and sad events, but they usually don't cause a damage to a third state. That would more be the case when a spacecraft re-enters uncontrolled from outer space and then crashes into the territory of a third unrelated state. Then it would be the classical example to trigger space law liability.
Wow, Christopher, you want to add on top of that?
Beautifully, you know, I can't top that explanation. That's exactly it. It's very complicated and it's very simple to break down. There are a number of dimensions to it, but yeah, absolutely. I think the issue of fault is, to my mind, also a technical issue, because actually proving craft A affected craft B, you have to show the causation and you have to show the damage. And again, you know, it's an instrumentation problem as much as anything. How do we do that? Is the persistence of observation on the satellite? Do we track it all the time that we can say that definitely caused that damage? So it's really, really tough there. And in terms of damage on the surface of the Earth, well, again, what we as lawyers really like is precedent. We like to see what's happened before, and there isn't the precedent here. We thought we had it in the late 1970s, 1979, when a Cosmos satellite crashed in Canada. But that was not settled through the liability convention mechanisms. That was settled as an independent, out-of-court settlement, if you like. So, yeah, it's an area that I think we need more activity on, but we don't want any activity on because it means there's been a problem.
And you previously mentioned that the damage needs to be caused by a space object. Now, how is a space object defined?
In the liability convention, Article 1 puts all the definitions down, and it's got this, I think Article 1D of the liability convention, if my memory serves me correctly, defines a space object as a space object or a component part of a space object. So essentially, it's everything human made that goes into space, be it a full satellite, be it a rocket fairing, be it an astronaut's glove, anything that is human made goes into space will become a space object.
Now, okay, I have a provocative question. What happens if it's not been made by a human, but rather by a robot? Let's say somebody mines minerals on the moon or a celestial body, and that somebody is actually a robot or a mechanism, and that mechanism builds a castle. Now, is that still going to be a space object according to our rules that currently exist, or is that going to change?
The thing about the outer space treaty regime that we've got is there is always a state on the hook for it, no matter what. Whether you know, if the robot's been put there, it'll have been put there by a private company. That private company will have a state. and it will have been launched by a state. So there's always a state on the hook somewhere down the line. It might be, as I say, you know, second, third, fourth chain. You know, it might be a robot that's been created by a robot. Doesn't matter. Eventually, you'll be able to trace it back to a state. There's always a state on the hook, and that's where the liability sits. That's where the international responsibility under Article 6 sits. And if there's a state of registry, that's where Article 8 kicks in as well.
All right. And then there's another question that we have, maybe a bit off topic, but is there like such a thing as the environment in space? Because we now have protection of the environment on Earth, especially because we have huge companies dealing with a lot of issues and putting into the environment a lot of emissions. And then you have certain responsibilities in place along with the environmental impact analysis. Now, the Outer Space Treaty also mentions some sort of analysis, the impact analysis that needs to be made. Does that suggest that the outer space is also perceived as the environment, or how does that work? Too broad of a question. Okay.
I think we're waiting. Who gets the question?
Who is most fit for that question? Yeah, I haven't really thought about it. Maybe Alexander, you can take it on.
I'm not sure if I'm the most fit, but since I opened my mic channel, I guess I have to say something now. Also here, first a simple answer and then some explanations to it. And please, Chris, Jennie, anyone who wants to add something. I'd say, yes, the environment is or has become an element of concern when we talk about outer space. It has maybe not been in the same way a concern from the very beginning. It's awakening. It's awakening. There is, as you correctly say, the environment already mentioned in the Outer Space Treaty. Although if you read it, it's more also concern not to bring back extraterrestrial material that could harm our terrestrial environment, and not to do it the other way around, so the famous forward and backward contamination. But for many years, let's face it, concerns about the outer space environment, polluting that environment, were not really the top priority. Why? Because space itself, space flight, was a completely new domain. So there were other challenges than thinking of the impact of what you were doing. There were comparatively few space actors. At the very beginning, it was less than a handful, basically, of space actors. And that has profoundly changed, as Chris mentioned, and Jennie, you also said more and more space actors. And so what we see is that the orbits around Earth, certain orbits, not all, are getting more and more polluted with remainings that we left in space, because it takes a while, despite the help of Sir Isaac Newton, it takes a while that things come down again. And they can be pretty dangerous up in space. They travel with an average speed of plus minus 30,000 kilometers per hour around in the low Earth orbit. And if they hit another object, you know, the impact can be devastating, and you cause more and more of this, what we call space debris. And you pollute bit by bit more and more the environment around Earth. And that has become really a concern that is being addressed in recent years. And there's a new catchword that we know from terrestrial problems and terrestrial law, and that is sustainability. How do we use outer space in a way that future generations can also still use outer space? How do we do things in a sustainable, in a safe and in a secure manner? And this is a topic that 20, 30 years ago, you would not have found at COPUOS, the United Nations Committee on the Peaceful Use of Outer Space, but also not at the everyday life of a space agency and space lawyers. Nowadays, yes, sustainability, environment, those are big things we all are concerned about, and that's good. And that summarizes a bit, answering your question. Yes, the environment is a concern, both out of a concern for the environment and, let's be honest, also for self-interest. If I pollute outer space more and more, I will have trouble flying into outer space tomorrow. So it's in my own interest to clean up there and to mitigate the consequences of my actions, your actions, and your actions.
Such an amazing contribution. Thank you, Alexander, for actually explaining that to me. Primavera, you have a question. Jump in, jump in.
No, I just wanted to add to this because I think it's actually a very important point to highlight, which is, of course, like this is kind of like, this is one of the things we know we are not good at in terms of global governance, is addressing environmental questions, because we are all focused on our own territory, our own short-term gain, like basically because we are fragment the world into different sections, then of course everything that is not within our section, we won't care as much as everything that is within our own territory. So we have seen, and I mean the problem that the problem that we're doing today with like climate change and so that is to me a very clear illustration of the failure of global governance to understand that there is actually an incentive to all collaborate in order to be sustainable, even though maybe we will reduce our own little private profit. Eventually, it's going to be better for everyone and even for us. We've seen it already at the planetary scale. I think we should not assume that just because all of a sudden now we're thinking about the space, we will think about it better, unless we actually implement specific mechanisms and unless we really explicitly realize the fact that this is a problem that existing territorially based approach to governance have failed to address. And I'm just going to propose one little suggestion just because that's all I know. In terms of blockchain, I think, so one thing is like creating a treaty and like agreeing not to exploit excessively whether the orbit or the planet. The other thing is actually how do we actually design it and embed it into our existing institutional frameworks so that it's not just we are all limiting ourselves, but it's actually we are constructing something in which it is economically convenient today to act in the interest of the planet or in the interest of future generations. So within the blockchain space, there is a few experimentation that have been done with regard to like impact tokens, which is essentially taking the concept of carbon credits in order to make sure that whenever you're creating something that is positive for the environment, that has a positive impact on climate, then you get issued those tokens, and then people that actually have a negative impact on the climate, they might be required to purchase those tokens, or vice versa. If you just want to support the activities of those people, then you can also purchase those tokens. So it's about creating some kind of traceability on what is the process that are being used by different actors, but also adding this economic incentive, because it seems that in the current society in which we live, like economic incentives are oftentimes prevail over the collective incentives. And so creating mechanisms by which we're actually understanding a little bit how society operates, then we are sanctions through this tokenization system in order to encourage, in order to bring back the long-term positive effect and long-term negative effect back to the present, so that we can feel today what is the cost of the what is the cost of the externalities of the action that we're actually carrying on.
That is incredible. I mean, tokenization is a very interesting topic. I do believe that there lies an open path in the future for actually introducing new models for improved governance, and the economics is a huge part of that, absolutely. Maybe just a question on top of that. I mean, since we previously discussed that, Jennie, you were working within these big corporations. How do corporations talk to the governments, or is it more or less the governments are imposing the rules on the corporations? Is it that the corporations, because how it looks to me, to be honest, it looks as if the SpaceX is very much colonizing the space to some extent. And it does seem as if the private sector is more or less going into the space and not so much the nation states alone. So is it that these dynamics are switching? Is it that we are now going to be observing the global governance run by the private sector very soon, or is there any mechanism in place?
Well, I think it's definitely the case that there's more and more actors, and those are from the private entities. But as Chris previously said, there is always a state in the hook, so that there is always a national state who's authorized and who's responsible for the supervision of those activities. So So yes, the governance is still in the hands of the states, at least at the official level. And I think there is actually, just going back to the if I may, to the sustainability issue mentioned, that I think it's exactly a good example where we can see where the private industry and the state's interests do converge, due to the fact that the state and the near Earth orbits, I mean, they have to remain usable also for the businesses to thrive going forward. But nevertheless, we can still preserve the idea of preserving outer space also for the future generations. So here, it's a way to see the issue of sustainability from two different angles, which actually do serve the interests of the private entities as well as the governments. And I think here is a good example from the COPUOS side, is the long-term sustainability guidelines, the 21 of those, and accepted in 2019, that the national implementation of those guidelines is able to set certain norms of behavior at national levels. And if we see a good level of implementation of those rules by the states, and as well intergovernmental organizations in their practices through different kind of instruments, there we can see as well possibly a bit of norms of behavior in that respect emerging. But of course, there is always there needs to be some sort of a convergence, and there needs to be a discussion between all the actors as well, also those ones that are not at official level able to set such norms.
And is that perhaps the reason why we are switching more and more towards the soft rules and the guidelines, so that we enable more maneuvering space, or not? What is exactly the reason? Because I know that, for example, for the satellites, right? And Alexander, you previously mentioned that there is quite a lot of satellites and quite a lot of debris already in the orbit. And we only now have presented the guidelines on how to tackle the debris issue and how to prevent these environments to be too dense, so that we still have the possibility to, launch the satellites into the orbit and still have the space to maneuver normally. Is that the reason why we are introducing so many soft rules, or is there anything else underneath?
Well, I wouldn't say that is the reason. That is maybe the effect. So to put it in other words, Chris has explained before, this treaty making was a period that came to a gradual standstill in the 1970s, 1980s, and since then it's difficult for many reasons to establish new international principal treaties like those that have been explained in this panel already. And in order to help out, so to say, I'm simplifying a lot here, but in order to have at least some sort of guidance, certain soft law instruments have been conceived, that be UN resolutions, for example, over the years, giving some guidance on applying the existing treaties, but also technical standards, for example, from the International Organization for Standardization, ISO, or other technical bodies, and many other things. So soft law is, if you wish, on the one hand, filling a gap left by the inability today, or the difficulty to come to new law. I don't want to call it hard law because it's law, to come to new public international law, treaty law. But on the other hand, it's not just a gap filler. Soft law, and there you have to be careful what type of soft law you mean, has also its benefits and its very specific function. And if you give me 60 seconds, then I explain you that on the example of space debris. That's what we've just been talking about. So for many years, it was very difficult how to tackle this problem of growing space debris, trash in orbit, because it was precisely also what Primavera mentioned before, the question of cost and who should be responsible on a global scale for it. It's the same thing that we saw in the climate change debate. Yeah, those polluting should pay, the polluter pays principle, or some other sort of thing, idea of taxes to be applied when you want to go into outer space. Hundreds of ideas floating around. But the other problem was, what do we technically do? How do we do this? And in this environment, at some point, engineers actually got together. Again, I'm speeding up the story. Engineers from several space agencies around the world and said, we are defining now technical guidelines, what to do in order to mitigate space debris. And so they came up at the so-called Interagency Space Debris Coordination Committee, IADC, with a bunch of technical guidelines, what to do to reduce causing space debris. And they were able to do that because they had the luxury to cut out completely the economic dimension, the geopolitical dimension, the social dimension, the legal dimension. They didn't say who shall do it, who shall pay for it. They said, how can it be achieved? By switching off batteries before the satellite has no energy, by depleting energy reservoirs on board of the satellite, by putting them low enough so that within 25 years they come back, And once this technical set of guidelines existed, actually, the policymakers and the lawmakers got interested in it and said, wow, that's actually very useful. And suddenly this thing got turned into the UN Space Debris Mitigation Guidelines. And nowadays, national legislators, when they define the catalog of conditions to get a license at national level, they make reference to these documents. Say, well, if you want a license from me to fly into outer space, show to me how you respond to the IADC Space Debris Mitigation Guidelines, and then I let you go up there. And so you see, soft law can take many ways, has many benefits, has also disadvantages. It's not only good to forget law and go to non-legally binding things, but sometimes it has its merits. That's my take and my view on that subject.
Amazing. Thank you so much for that explanation. I see that we only have 10 more minutes, so I do want to drag our attention towards the future aspects and what lies in front of us. What are the biggest issues that you think we have to deal with in terms of the space domain? And what do you think is awaiting us in, let's say, next 5 years or maybe next 10 years?
If I can jump in with the pressing, the thing that keeps me awake at night as a space lawyer, an academic space lawyer, space traffic management. How are we going to get the management of the different orbits of Earth? How are we going to manage that? We're going to need to. There's more stuff going up there than ever before. How are we going to coordinate that? There's theories of regulation that can help us, but they're possible solutions. Eventually, the international community is going to have to pick a solution. There's not a shortage of ways of doing it, but there needs to be an attitudinal shift to say, right, that's what we're going to do. And it's going to involve information sharing, and lots of it. It's going to involve pulling stuff out. I've got a great collaborator that I work with, a guy called Ralph Dinsley from Northern Space and Security, and he calls it the military firewall. We're going to have to pull information out from behind the military firewall so we know what's happening up in outer space. And I think that's the thing, that's the challenge that I would look at. Do we go for a big regulatory system where everyone's managed, or do we go for, just information sharing, telling everybody what's out there and relying on the Article 9 due regard, all space users have a duty of care to other space users, and let that work out. So that's the thing that I think, in a very short sort of summary, where I think we need to be looking.
Amazing, thank you. Who wants to go next?
So I'm gonna talk with the premise that I'm not a space expert, but I just really enjoy navigating through the analogies between the internet and the space. And I think in the earlier days of the internet, there was like a similar question of like, well, how do we enforce specific types of regulation? How do we govern this polycentric structure? And so one thing that I still continue to find fascinating is the way in which the W3C has acted in order to ensure that there is some form of standardization and interoperability. And it was actually about finding what is the weak points that everyone will want to agree. So it's easy to make treaties, but it's also easy not to respect treaties unless you have like a strong enforcement mechanism around them. And so what they come up with as an idea, and I would be very curious to explore and to think what will be the correspondence of this in the concept of space, was actually creating a patent pool in which no longer be built because patents, right? And so no innovation could happen anymore except big company purchasing all the patents from everyone. And so the W3C proposed to create this patent pool, and the rule is that if you have to agree by the standard, by the protocol, by the specification that the W3C gives, which is some kind of internet treaty, if you want to interpret the concept of treaty in the most broad sense. And the benefit of that, because why would I join the treaty unless I actually have an immediate benefit, was I get to be part of this patent pool, which means that I need to put all my patents in the pool, but I also get to use all the patents that are already part of the pool. And so you create a very, very important and significant gravitational force around that, so that more and more people that eventually all the patents are in the pool. So the only way you can use anything is to be part of the pool and therefore join the treaty. And so it's kind of like finding this one thing, which is intellectual property law, which we know every government respect and which we know already have some form of reciprocity between like all the treaties and conventions that exist, and using this as a tool to create such a strong honeypot. Right? I want to be able to use those patents. Hence, I'm going to agree to the terms of the patent pool. Right? And so in the case of the internet, it has worked really well. And today, like the reason that everyone is respecting the standards is in large part because otherwise they would be infringing the patents. And so this is kind of my question is like, now that we need to think about the years ahead, is there any kind of little hack or mechanism of this type that we could do in order to ensure that there is a common pool of resources that becomes kind of the enforcement mechanism for actually a very disparate and different set of rules towards like common heritage, towards whatever we decide to do, but that cannot be enforced. And yet, because there is this strong pool in intellectual property, we can enforce through that.
That is an amazing question, and perhaps opens the floor to another panel, which we might be having for another year. You want to answer?
One sort of concrete example to bring us all the way back to the beginning of the panel is just to think again about registration, which a lot of folks, I mean, the other panelists here will know that this is a very sort of constellated ongoing conversation in the space community right now, is how are we going to extend the registration mechanisms that we have to as we move further and further away from the Earth. And, you know, as we start to look at the moon and see more activity around the moon, we start to look at resources, we start to think more about the environment of the moon. There's a lot of opportunity for us to construct institutions through new tools, through new mechanisms that will kind of bring together the different incentives of different actors and actually generate, as Primavera is saying, a common pool that we share. But part of that is about, you know, that's really a design process. That's not so much about saying, how are things now, but rather how do we use both the tools of the space domain that we have, the treaties that are already in place, and then also start to look at these other analogies and these other resources that we have, like blockchain, just more as an analogy, as well as a direct mechanism that we can incorporate in order to generate these new kind of institutional frameworks that may be functional and legible outside of the terrestrial domain, in a way that they wouldn't even make sense here, but that's okay because it's this new realm. So I think there's an opportunity to be more normative in that way, as opposed to we don't have to limit ourselves to the positive side as well.
Thank you so much. I'm being very mindful of our time, and I know that the time has actually passed, but Jennie and Alexander, I do want to give you the final words.
Well, I'll go first then. Just quickly, I think what has already been said is highlighting the issue that things are quite complicated, and there's a lot of confluence between different normative levels, international and national law, then between binding law and soft law. And as well, there is this diversity of interests within this arena, and that sort of like the balancing activity, how to deal with these complex and to some extent also issues that or activities that might not all be good. That how to find ways to balance the interest in such a way that we can preserve the outer space as it is initially envisaged, but as well to allow for new activities and to allow for the societal benefits that we can derive from the activity. So I think mine is the balancing issue for going forward.
Such a great future-oriented narrative, also very much aligned with the negotiating the new normal. Alexander, do you want to add something?
Well, mindful of the time, I will attempt an experiment and summarize what I wanted to say in one sentence only. If you ask me about the challenge of space law in the next 10 years, for me it is how to maintain cooperation and coordination in order to effectively manage space flight and societal expectations around the world.
Oh, wow. Amazing contributions. I mean, I very much appreciate and I'm grateful for everybody to be part of this panel. There's going to be another space panel happening on Monday at 2:45 Central European time as well. Please, everybody join us because we're going to be diving into the space laws even more into details, maybe mentioning a bit more about the Artemis Accords and about what is really happening with the regulation of the space activities. This was an introduction. I hope that today you got a bit of a glimpse into how the space law actually functions, what it is, what it presents, what are the treaty kiddos or children's out of the outer space treaty. And hopefully you enjoyed the conversation and will join us again on Monday. Thank you, all the panelists. It was an incredible discussion that you provided today.